Welcome back. You're watching Prime Property. Time now for Property Doctor, when we get experts to answer your queries. This week we've got to our studios Niraj Kumar, partner at DSK Legal. Thanks, Niraj, for joining us here on Prime Property. He's got 10 years of experience when it comes to the real estate sector. Let's get down to business. Our first query of the day is coming in from Ronak Ram on the Provident Harmony project in Thani Sandra in Bangalore. He writes in, I booked a flat in block A9 on the 5th floor, but the agreement has not been signed yet. Now the builder calls me up and says that the same flat had been booked by an NRI 2 years ago, but since he did not make payments on time, that flat was kept open for sale. The buyer is back and is claiming the flat. So Provident is asking me to take another east-facing premium flat for the same price. The problem is that there are big quality issues in the new flat, plastering issues, cracks in walls and ceiling. Would like to know your view. Is it advisable to take back my booking amount and look for another project? Niraj, what is your advice going to be for Ronak? He already sounds a little disappointed and disheartened by this project.
I'm assuming two things from the fact that he has set out. One is that he was not disclosed the fact that this property, the flat that he is actually buying, was earlier sold to somebody, and that the builder has not yet settled that account with the earlier buyer and is selling this flat to the new buyer. So from my perspective, this is a material disclosure, non-disclosure, or active concealment of very material fact, which makes the whole transaction a fraudulent one. And his concern that there is no agreement as on date doesn't matter much. I am assuming that when he must have paid for the booking amount or subsequent amounts, then he must have got an allotment letter, and this is a very much enforceable document. He has two options. One is to stick to the property, the flat that has been originally allotted to him, and it is for the builder to sort out with the earlier buyer how he settles it. Secondly, in case he is completely dissatisfied, then he definitely has an option of repudiating the whole contract, because if somebody whose consent has been obtained through some kind of fraud, active concealment of fact, so he can repudiate the contract, he can ask for his money back and ask for damages. But will he have to talk tough
with the builder? Is he going to have to talk tough? Because, they might even say there's a cancellation charge.
Yeah, so definitely he has to talk tough on this. He will say that there is a material concealment of fact and that he can repudiate the contract. And he should actually issue a legal notice to that effect in case he wants to exit without pay. And he should also demand damages to the builder.
Okay, Ronak, I hope that helps you out. On to our next viewer query. We've got Deepak Jain on the phone with his query. Thanks, Mr. Jain, for joining us here on Prime Property. What's your query?
I had booked this Unitech Unihomes project in Sector 117 Noida in 2009, a two-bedroom flat. And as per the agreement, I was supposed to get the position in like 2 years' time. But now, in 2014 also, they are talking to give the position in 2017 or 18 only. And I have taken a huge loan and I am living in a rented house. So I have the problem from both the sides. So I want to know what legal action I can take against them, because I have already paid more than 20 lakh rupees to the builder, like Unitech.
So sir, your rights flow largely from what is provided in the agreement. What are your entitlements in case there is a delay in delivery of the product by the developer? This must be captured in the agreement that you have signed with Unitech. Look at the provision of that agreement. Normally it provides for some kind of compensation to be paid to the customer in case there is delay in delivery. Please call upon the developer to pay you that on monthly basis. To a certain extent that will assuage your immediate problem as far as your financial constraint that you are facing today. In case, because with the promise was to deliver in 2 years, and more than after 5 years you do not have a visibility when you are going in another 2 years or not, then you have also a case of going to the court seeking damages, which can be much higher than what is provided in the agreement.
So he'll have to go to consumer court?
Yes, he should go to consumer court.
On to our next query of the day. It's coming in from Kedar Kulkarni. He's also joining us on the phone line. Kedar, go ahead.
Yeah, hi. So my question actually is, I have invested in two properties of DLF, both in the Garden City township of DLF in New Gurgaon near Manesar. So one of the properties is under construction and the other property has already been constructed and the possession has been handed over to me. For the flat which has already been completed, in this case, DLF has given us the position, but it is not, registering the property. It is postponing or avoiding the registration on the ground that our Resident Welfare Association has filed a case against DLF with the Competition Commission, on the same lines as the Bel Air or the Park Place case. So DLF is insisting that it cannot register the property unless the case is withdrawn. So is DLF legally right in doing so, and what is the solution here?
So on the completed project where DLF is resisting transfer of the property or the registration of the final document on account of RWA having moved to CCI. And when you say that the CCI application before CCI is on the same lines as the Bel Air case, so I'm assuming that that's a similar case where DLF or the developer has used additional FSI available in that area, and at the cost of the common areas being already sold to the already sold units. If that is the only thing that has been agitated before CCI, then I don't think DLF's stand is correct one. But in case it has larger issues where you have sought amendment in the agreement that DLF has signed with you people for the units with the unit holders, then, well, technically speaking, they may be right here in saying that in case this agreement is to be revisited in line of your application lying before CCI, then let's have the final document, and that our document can get registered.
Are you saying this also because, Kedar, if I'm not wrong, this is a project that came in post 20th May 2009. The compact ruling, the CCI ruling so far has been that, DLF only has to modify buyer agreements post that date.
True.
So is that what you're saying?
That is what I'm. And more importantly, in case the application lying before CCI, you never know what CCI is finally going to direct in this particular case and what specific clauses are to be modified. So that's why I'm saying this.
I mean, here, just to answer the question, our grievances before the CCI are manifold. I mean, what you mentioned is probably just one part, but we are under there are many grievances that we have raised broadly under the category that it is a one-sided abusive agreement. So, and there are many, issues that we have, including the compensation that they are giving us, which is just right now 15 rupees per square feet or 10 rupees per square feet, which also we believe is much less. So there are a host of other issues that we have raised in the CCI application.
Sure. So Kedar, that was the reason when I said that in case you are seeking amendment of the agreement that you have already signed, then the conveyance document that is to be entered for the conveying of the document, conveying of the property from DLF to you or other unit holders. So what is the contours of that document? So that document is basically before CCI now. So unless until contours of that agreement and the clauses of that agreement are settled between the parties, based on what document actually the conveyance will take place. So that is the issue. So that may be one of the reasons why DLF may be registering the document today.
Let's go on to our next query. This is going to be coming in from the phone line, Subhash Arora. Over to you, Mr. Arora.
Actually, मैंने एक property buy करी थी in Bhiwadi, and the developer name is Terahan Home Developer, and the project name is Status Residency. In April, I applied for this property, and I came to know that, in a week's time, I came to know that, these people have sold me the project on the basis of previous layout that the project had. And now the new layout is such that two building of 14 floors coming face to face, and there is no ventilation in between. So now these people are stuck that, we won't refund your money because, it's your mistake that you have cancelled the project. Although these people have sold me the project on the basis of old layout, which is, properly placed building, and there is a good ventilation in between. Now there is hardly 25 to 30 feet gap between 14 floor building. So I don't know what to do because, these people have rejected that they are not going to refund the money.
So what are his legal options?
So I understand from the question that when you bought the property, there were new plans already sanctioned for the project, but you were sold the property based on the old sanctioned plans. So I'm assuming that you have evidence to that effect.
Yeah, I have everything in mail.
True. And secondly, while giving you the allotment letter, they must have earmarked a particular unit as shown in the tower, which was actually part of the original plan, not the subsequent plan. Am I right in understanding that?
Yeah, correct.
If these are the facts, and on that day when you issued the check and you had a new plan, the developer already had a new plan sanctioned, then you better go to the police, lodge a complaint for cheating. In case police is not taking action, follow it up with a criminal complaint with the magistrate's court, because this is upfront case of cheating where you have been sold something, showing something else, whereas they already had sanction for something else.
Well, Subhash, I hope you're satisfied with the solution that's been provided to you by Niraj. And Niraj, I want to thank you for taking the time out to joining us here on Prime Property. We look forward to having you back here.
Sure.
We're completely out of time, so we have to wrap up this edition of Prime Property. Do remember, you can always send us your property queries, feedback, experiences with developers that you want to share. Our email address is primeproperty@network18online.com. You can also tweet me. See you same time next week.